Welcome to another edition of FH&P Lawyers Law Talk. I'm Clay Williams. I'm a partner at FH&P Lawyers, and this is our show where we talk about all things legal. And so welcome to our listeners and our viewers now. We've got, you can get us on Spotify, YouTube, Apple, and also now Rogers TV. So it's been really great seeing how our listeners and our viewers are growing and providing comments. So keep it up. It certainly helps us if you provide us with a thumbs up or a like. And today, you're certainly going to want to do that because we've got an interesting show for you. Today, I've got with me Marvin Geekie and Wendy Cheung, and they are the lawyers in our immigration department. So, welcome, Marvin. Marvin is the head of the department. Welcome, Marvin.
Thank you, Clay.
And also with us is Wendy Cheung. Welcome, Wendy.
Thank you.
With Marvin, you are the lawyers that practice in our immigration department.
That's right.
So I'm going to start it out here and just say with a big wide-ranging question, because that's what I do. I'm just going to throw you a softball here, Marvin. What do you guys do? Tell me about the types of things that you guys handle in the immigration department.
Well, we like to think that we're, as far as the immigration department goes, Clay, just like the FH&P lawyers, we're a full-service immigration department. We like to do pretty much everything, although even though we have done some economic kind of immigration, that's not really our bread and butter. Mostly our practice is, taking things through to judicial review, spousal sponsorship, LMIA programs. And prior to, last year's budget kind of thing, we did a lot more paths to permanent residency for people as well. But, with the federal government changing those kind of programs, cutting down the numbers as they have, those kind of pathways are not as open to folks. So we've kind of shifted what we do mostly out of necessity more than anything, because of course, people still call us, and they call our colleagues in the profession as well about what are the various pathways that are still open to them now. And unfortunately, a lot of times the news is really unfortunate.
But I suppose that's part of your job, is to try and find a pathway that people can take.
Absolutely, it is. And, we will bend over backwards to try and find, a suitable pathway, that makes sense. Not to try to shoehorn, a square peg into a round hole or anything like that, because I think at the end of the day, it still has to be a round peg fitting into a round hole. So, it is, though, heartbreaking when people, because you have to remember that, when the government says, well, our numbers used to be 650,000 people per year, we're going to cut that down to 380,000 people per year. Those are still people, and those are people's lives that are being affected. And we try to keep that in mind when people come and see us and talk to us.
It still sounds to me like a large number, 300-something thousand people. Is that, and what does that number mean? Is that the number of people that are coming to the country for all the different programs, or is that the pathway to permanent residency? What is that? Where do you get that number from?
Well, that's a number that's put out by the federal government, and it is a pathway to permanent residency for a lot of folks. And you got to keep in mind that, within the program there are other categories as well. I think students are on top of that, but the student numbers are really cut down as well. I'm sure folks are seeing in the news, headlines about university cutting programs or thinking about having to close altogether because the international student revenue just isn't there, and that's as a result of those numbers being cut down to such a significant degree that, that form of, if you will, funding, because that's what, in a sense, what it mounted to, is no longer there.
What is the judicial reviews, and what is that all about?
Yeah, so talking about judicial reviews, that's basically a procedure where actually lawyers come in really effective because it does require a court hearing. And it requires a lawyer to go to federal court to review or appeal a decision that's already been made by an immigration officer.
Okay, so actually that was one of the questions that I had is, why a law firm? I wondered why is it important that we have an immigration department as opposed to just an immigration consultancy firm? What is why lawyers, I guess?
Yeah. Well, as lawyers and particularly litigators, we are trained in the skill of advocacy, both written and oral. And I also practice in other areas. And so knowing the various steps to go from writing your appeal claim to going all the way to a federal court hearing, that is a skill that we have honed since we started in this profession. And that is something that we're comfortable doing, and that is something that we are familiar with.
Marvin, any stories for us or about, what happens sometimes when you get a file? Is there already some issues that have often developed?
Oh, yeah. By the time you're off the judicial review, the issues are pretty well defined. And, the beautiful thing I think about federal court as opposed to, say, general litigation in the province of British Columbia generally is that the federal court is fairly highly regulated, and it likes to do things according to very strict adherence to a time schedule that are built right into the federal court rules. But just to backtrack for 1 second and build on why perhaps if you're facing a judicial review, why you want to retain a counsel is that immigration consultants have the ability to prepare written submissions, but they have to be careful about what level of appearance they're going to be making, because they're allowed to appear at certain levels, but not other ones. And so we, of course, have no restriction like that. But just to give you an idea, Clay, with respect to, the challenges facing a judicial review, in 2025, there were 30,000 immigration filings in the federal court, for these judicial reviews. That's a 20% increase over 2024, which saw a similar increase over the year 2023. So you can see that things are getting really quite jammed up in the federal court. And that's exactly our experience too. So, for example, leave dismissals, because you have to get leave in order to go to the federal court first, and then you get to do your judicial application if you get approved first. Your 6 months to get a leave decision now, and 12 months to get a kind of a decision to get leave granted. So that's the initial step. So you're looking at 6 months to a year. And so I guess, the longer it takes for you to get your actual leave, the better off it is for you. So, and then to get off to a hearing is another 15 months typically now. Now, the immigration rules specify that you should be entitled to have that hearing within 60 to 90 days. But obviously, the federal court is so busy now that 60 to 90 days is off at 15 months. So judicial reviews are a very important mechanism. And I think, Wendy can tell you why it's an important mechanism, but it's an important mechanism because it is often your last line of defense. It's like, IRCC, who you can never talk to, makes a decision that you don't like, and you're not left with any kind of recourse. You're off to the federal court with that. And the IRCC now is employing a lot of AI to make a lot of their decisions. So, as we see, a lot of those decisions are flawed. The AI model that they're using or whatever is not employing the kind of factors that a human person would do. And so you're seeing these kind of like really hairy decisions come out of the IRCC, and you've got really no choice. And there you have it. That's the reason for 30,000 immigration filings, which, by the way, is 80% of what the federal court does now.
So the IRCC, just for our listeners, what does that stand for?
Immigration and Refugee Citizenship Canada.
Okay, so what are the decisions that you get involved with in doing the review? Is it all deportation, or is there something else?
No, it's again, it's very wide ranging. You've got your typical deportation scenario, of course, but you've also got denied spousal sponsorships. Or a negative decision on some other kind of application that you had to make to the IRCC, like a work permit, for example. And so it really can be quite frustrating, because what you thought and put forward as something that's relatively straightforward apparently isn't.
Well, tell me what do these poor people do while they're waiting for a decision? Are they allowed to work? Are they deported? What happens? Is there a stay to allow them to argue their case?
Wendy, do you want to take that one?
Well, the standard lawyer response is, it depends.
Of course. Yeah.
And so it depends for what reason they were denied whatever application it was that they tendered to the IRCC. And I do want to pick up on a point that Marvin made, which is that these applications, they ultimately go to an immigration officer for a decision, but the use of AI is incredibly prevalent now. And so whatever type of application we're pushing through or an immigration officer is looking at, let's, for example, use a spousal sponsorship. There are very personal facts that go into these applications. And I imagine what the AI does is review these very personal, detailed facts that are very specific to each application and comes up with effectively a response that may advise the immigration officer, and the immigration officer will use his or her judgment to develop a response, or may just go with what the AI recommended. And a part of the reason for the judicial review, ultimately you go before judges in a federal court. They are human, and they decide not what their decision would have been if the application came before them, but whether or not the decision of the immigration officer was made fairly and according to law. And in effect, in today's day and age, they're really seeing whether or not AI made a decision that was fair and according to the law.
Is it official, or are you guys talking about AI providing a synopsis of the facts or something that is then dealt with by an officer? Is there actually AI making decisions now?
To build on what Wendy said, is that, I think what's supposed to be happening is that the IRCC officers take, whatever the AI feeds back at them, and are supposed to make a human decision with that information. But what we've got now, or what IRCC has now, is an incredible workload. We've all, I talked about the decrease in the numbers that the government brought into its budget last year, but prior to in the years leading up to last year, the immigration numbers were really quite high, and with that high number of people that we're letting into the country, of course, there has to be a corresponding application or applications that attaches to each one of those people, right? And so there's no impetus on the federal government to try and get more staff, for example, to deal with, the volume of applications that the IRC is experiencing. And so you've got the same number of people trying to slog through an increased number of cases, and you can see the backlogs increasing. We're dealing with, for example, with a work permit. A simple work permit application is 250, I think it's 2 or 6 days now, where it used to be you could get a work permit in 80 to 100 days, which is still a long time. But now when you're talking about 9 months for a work permit application to make a decision on, that's assuming that you didn't make a mistake on your application and the thing gets returned. After 252 days, you don't want to find that your work permit gets returned because you failed to check a certain box off, So these timelines have very serious consequences for people, and it causes, I think, the government to take certain steps that maybe they don't want to make. So that's the situation we find ourselves in.
Yeah, and to add to that, Marvin, these timelines are impacted by things that sometimes are out of an applicant's control, such as, immigration is one of those things where what happens globally can very well impact one individual person's application. So we can get a swell of applications there was a big swell of applications from the pandemic. So we saw in those years, applications were just, there were so many, and the government, had the same amount of workforce working on probably 20 times the applications during that time frame. A couple of years ago, it was refugees coming to the country because of situations happening outside of Canada. And so we are really at the mercy of what is happening globally that sometimes swells the numbers and extends all these timelines that used to be standard. I don't think there is a standard anymore.
Wow. Okay, I want to talk a little bit about, now we've talked about judicial review. To me, that sounds like kind of the end of the process. There's been a decision made. I always like to think of us as lawyers as problem solvers. And is there something lesser that you can do? Do you sometimes get a file that is, that you've got something that you can do other than immediately going to court? And I'm probably speaking to you, especially because I know that with your background in mediation and arbitration, do you have any comments on that?
I mean, in the immigration practice, of course, we can also do everything that an immigration consultant can do. And in fact, we do have 2 staff members of our team who are immigration consultants. So we also do accept work where we are working on what I would like to call a first level application. So an application for a work permit, an application for PR. So that can come through. And if we're successful, then we don't need to appeal or review and go to a court. And in those applications, there is no court, there's no judge. There is an immigration officer that makes a decision. Now, if it does get elevated to an appeal or review decision, the end goal isn't necessarily always court, but yes, absolutely, we have dealt with circumstances where in the process of getting the appeal submissions in, we might get a phone call from the federal court to say, hey, what about, let's have some talks about what resolution can look like so it doesn't have to go to a full hearing.
Okay, and what about, are there different paths that you can take or something to assist people as well? Maybe they've been put down the wrong path or have put the wrong information in. Like I say, I like to think of ourselves as problem solvers.
Absolutely.
One of the issues that we always have to keep an eye on, Clay, is that, when it comes to the judicial review, is like the application got denied. And so therefore, what does that do to the person's status in Canada? Because you always have to maintain a good status in Canada, because if you don't, of course, the CBSA is going to come knocking on your door and say, time for you to go. Luckily, not like ICE is doing it out of the border, but it's not a dissimilar process, and we could certainly foresee the day when that process becomes a lot more aggressive. Luckily, we're Canadians. We do things the Canadian way right now. So, it isn't all that aggressive. But if they lack the status, that's always the danger, is that, they have to leave Canada and go home. So even if their application is denied, rightly or wrongly, they're probably going to have to do some sort of step then to restore their status or make a different application that is going to get them some status. And maybe they will have to leave Canada for a little while. And if they do, oftentimes, Clay, it's better if they leave voluntarily rather than have CBSA escort them to the border.
Wow. Do you ever have to make emergency applications?
We were in the position of having to go to the federal court for a stay of a deportation because the person's deportation was imminent, as in like within the next less than a week, they were going to be deported. The problem is oftentimes when we talk about access to justice issues is it's expensive, right? And so, and if you're talking about somebody who is an immigrant or a refugee or an asylum seeker, one of those, and perhaps maybe even somebody on one of the spousal sponsorships where the spouse has decided, you know what, I don't want to sponsor you anymore. And then it's like, boom, they're out of status and CBSA comes knocking. Those people often don't have access to a lot of resources. So it's like, well, you know, what can they afford then? They probably aren't going to be able to afford you to be running off to the federal court to make applications on their behalf. And so it's like the devil you know versus the devil you don't. And so on the plane they go.
But, you know, I like that answer. So I think what you're saying is you'll tailor your response appropriately to the situation. But it sounds like there's definitely some things to talk about.
Absolutely. And, we're always willing and wanting to talk to folks about the particular situation they're in because, it's not a one size fits all thing. We talk about judicial review, but really it is so nuanced and it's nuanced to each particular case. And I think Wendy can certainly talk to that because I know that, she's prepared the submissions on many cases where, the facts are nothing similar to each other. So there's very little precedential value to be drawn from one case to the next.
That's entirely true. And because I do dabble in other practice areas, I find that the facts of immigration cases, they're so different from one to another. And it's one of those areas of law where you do realize that a judge will make a decision based on things that are a lot, I would like to say, softer evidence. Evidence about relationships of people, about how tied they are to the community. Sometimes, and we do a lot of these, they're called humanitarian and compassionate types of decisions where we are looking at, appealing to one or three of the heartstrings of a federal court judge. So, I think that as each case comes to my desk, picking out the right type of evidence to use is incredibly important.
All right. Thank you to our listeners and our viewers for another episode of Law Talk, and we'll see you next time.